on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
We're about to go to war.
This courtroom moment takes a sharp turn fast. Judge Urich, who runs a tight ship, is handling a man who claims to be a sovereign citizen. It's unclear whether he's putting on an act or truly not all there. He's facing 2 charges of public misconduct after being seen behaving inappropriately at a park. What do you think? Real or just pretending? Let us know in the comments. And if you enjoy videos like this, be sure to like and subscribe. Let's get into it.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family and house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Markwood Woods, which looks like it was deferred as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000. Cash or surety, no 10% allowed at this time.
I've got to say, this judge really knows what he's doing. I've seen other judges try to handle these so-called sovereign citizen cases, and most either lose patience or waste a lot of time. But Judge Urich doesn't let any of that slide. He keeps things moving and calls out the contradictions in their arguments in a way that's both sharp and, honestly, kind of funny. The $50,000 bond he set makes a lot of sense, too. This guy already has multiple felony charges, and he's still pretty young. Letting him back out right now wouldn't be a good idea. Hopefully he gets the help he needs and turns things around. But to be honest, it's hard to tell if he's truly unwell or just pretending. What do you think? Let's get back to the video.
If Mr. Stringer wishes to bring various motions before the examining judge and That could include a motion to modify his bond. That is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on what is going on right now?
I'm sorry, sir.
I'm being charged. I'm being charged an entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
I'm not sure if you caught it, but during the second hearing, he actually said, "We're about to go to war." That's got to be one of the most outrageous things I've ever heard someone say. To a judge, if it were me on the bench, I would have hit him with a contempt charge right then and there. Now, we're jumping into his second hearing, this time in front of a different judge who doesn't hold back. Things really heat up in this one. What did you think about the first hearing? Let's get into the next part.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Lynn Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
Living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mott-Lewis, can you prepare an order for competency review?
Do you think the judge made the right decision by ordering a competency review for this defendant? In case you didn't know, when someone tries to fire their defense attorney, it can create serious issues, especially if they're not mentally fit to represent themselves. Without an attorney, they can't properly defend their case. And if the court finds them incompetent, it slows everything down and could even lead to their charges being dismissed. Even though this defendant thinks he knows it all, it's pretty clear there may be serious mental health issues involved. And if someone doesn't understand the charges or how the legal process works, it's like asking them to play a game without knowing the rules. It just turns into confusion and chaos. Let's get back to it.
I'm going to wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sanutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels me
Evaluation.
What labels me incompetent? My intelligence, because I have a high IQ?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I overstand the nature of the proceedings.
That you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father. and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number. He did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
I'm pretty sure this competency review will show that the defendant is dealing with some serious mental health issues. He's already been charged with several felonies, and it looks like that pattern might continue. Now, I'm all for second chances, but it seems like he's already had quite a few. It's hard to tell whether he's truly struggling mentally or just following the usual sovereign citizen playbook, thinking the law doesn't apply to him. The fact that he was caught behaving inappropriately in public does make me wonder if there's more going on mentally. What do you think? Did the judges handle this hearing the right way? Personally, I think they did the best they could with what they were dealing with. Maybe a contempt charge would have gotten through to him, but it's tough to say. Share your thoughts in the comments, and if you like this kind of content, don't forget to like and subscribe. Thanks so much for watching. Take care.